Great. And welcome, everyone, to our monthly meeting for lawyers who are involved in post-conviction investigations of wrongful convictions and actual innocence. This is a program that's supported by a grant from the Bureau of Justice Administration, which is part of the Office of Justice Programs at DOJ. And we present these webinars every month just as a way to provide additional training for folks on issues that come up to the work that you're doing across the country. One of the most requested topics we've had has been about ballistics. So I am very excited today to have the two folks who have joined us to be able to give us the view from the lab and the view from the bench. Just very briefly, Anne-Marie Kelly is going to be speaking with us first. She is the forensic laboratory supervisor and a firearms examiner at Philadelphia Police Department in the Office of Forensic Sciences. And of course, Judge Paul Grimm retired from the United States District Court for the District of Maryland and now at Duke University Law School. Judge Grimm presided over a number of cases from the bench and had to do Daubert hearings for ballistics issues, so is very aware and well respected on both sides of the bench. And I'm very happy to have both of you with us. Thank you so much. Anne-Marie, I believe you are starting us off. Anne-Marie is going to be giving a presentation talking about ballistics. What does a arms examiner do? What are the limitations? What can she do? What can she tell us? And hopefully also be able to address questions about dealing with old cases and trying to apply new technology for those cases to get better answers. As always, we ask that you have questions. Please put them in the chat. I'll be monitoring the chat and we'll be able to refer back to Anne-Marie or the judge with any questions that folks have. And then, as I said, after Anne-Marie's presentation, Judge Grimm will be with us and he will kind of give us some understanding of some of the reliability issues that may come up from his viewpoint as former jurist. So, Anne-Marie, the floor is yours.
Hi, so I'm just going to talk to you a little bit about firearms identification, how examiners can discern marks made by different tools, how, when I refer to tool, I'm speaking specifically about firearms, not other types of tools, but how those marks occur on those components and how they're transferred on the ballistic evidence. And then some of the things that are new in the science in comparison to cases that you may be handling that are, 15, 20 years old, for instance. So the main question, or the first two questions, are do different tools produce different tool marks?
Okay. Anne-Marie, yes. You're not sharing the slides.
Oh, it's not sharing?
I don't think so. Is everybody?
I can see it, but I can see the slides.
Okay, I think I just have my bad. Please continue.
Okay. I'm just going to go back for a second. I'm sorry. So do different tools produce different tool marks? And then can qualified firearms examiners reliably discern marks made by different tools? So in general, when we're talking about areas of firearms that impact fired ballistic evidence, we have breech face, extractor, ejector, firing pin, chamber that contact the fired cartridge cases, as well as barrels that impart marks onto fired bullets. And during the examination process, the firearms examiner will first separate evidence by class characteristics. They're measurable features of a specimen that indicate a restricted group source. They are a byproduct, or they're not a byproduct, I'm sorry, they are determined by manufacturer based on their specifications. So class characteristics of a cartridge case: caliber, breech face marks, firing pin shape, extractor and ejector shape and location. And for a projectile, you have the caliber, number of lands and grooves, the width of those lands and grooves, and the direction of twist. And the lands and grooves and direction of twist, for anyone who may not be familiar, is the rifling in the barrel that imparts a gyroscopic spin on the projectile, which aids its trajectory and its accuracy. So after evidence is broken down by class characteristics, the next thing we'll look at is individual characteristics. And these are random imperfections or irregularities of the tool surface that are incidental to manufacture, and they can be caused by use, corrosion, or damage. They are unique to that tool to the practical exclusion of all other tools. And then you have subclass characteristics. I think the topic of subclass is a little bit misunderstood. There's some Misinformation that subclass characteristics are always present and therefore prohibit examiners from reliably discerning tool marks made by different tools. In fact, subclass characteristics are features that may be produced during manufacture that are consistent among items made by the same tool in the same approximate state of wear. So to try and give this to you in a visual, if you picture a cutting tool, let's just say a screwdriver, and the screwdriver has a chip on the cutting surface, and you're going to drag that screwdriver over 100 pieces of metal consecutively. The mark from that chip may repeat on 20 pieces of metal in a row, maybe 30, maybe 40, until it changes, and then the mark looks different, okay? It doesn't mean that subclass characteristics are always going to be there or will always transfer, but they may transfer to a small group of consecutively manufactured surfaces, but not all surfaces made by the tool. So in tool manufacture, metal is either formed or it's removed. And typical forming operations in making a firearm are casting, which uses molten metal, and there's different types of casts that can be used, or forging, which uses a solid metal stock, which is then impressed or somehow molded or formed into the desired shape. So on the top left, you have a picture of die casting, and you have here your cast. The molten metal is poured into the cast, and when it cools, the cast is separated and the finished piece is here. In the production of firearms, these pieces are often subject to additional fine-tuning or machining. This is an example of hammer forging, very typical with revolver frames. And you can see here, basically, you have the impression of the revolver stamped into the metal. And then this is the finished revolver. And here you have some hammers stamped and then the finished hammer. And a very common use of hammer forging is for rifling barrels. And this is a rifling mandrel. It's a little hard to see here, but the rifling characteristics are imparted on this tool. It's placed into a barrel blank, and a number of tiny hammers will impact the external portion of the barrel, impressing these land and groove characteristics into the barrel. And then you have metal removal. And this is a list of some of the typical cutting operations that are used in firearms manufacture. Drilling being the probably most widely known, okay? This is the very first step in barrel rifling, and it's the foundation for the unique characteristics of each barrel. And as you can see on the right-hand side, as the drill cuts, it creates a series of concentric circles in the barrel, indicated by this green arrow. Then you have a process known as reaming. It's typically used to finish the bore or to further hone in the dimensions of the bore. And a reamer consists of multiple cutting surfaces, okay, that are all capable of producing individual characteristics. And I'll touch on that in a little bit with a video. This is a turning operation. You'll typically see this in barrel exteriors, firing pin noses, or bolt faces. And if you look at the image, now this is a side-by-side of two firing pin impressions, okay? These concentric circles here, this is indicative of a turning process. These are a class characteristic, so examiners will be very cautious when looking at this area. In comparison, these marks here, this is an individual characteristic of that firing pin. So this could be used for identification, or if these do not agree, elimination. But these here would be viewed cautiously. Grinding is the work of an abrasive material against metal. Produces very unique individual characteristics, so much so that High Point Firearms, for instance, we met with Tom Deeb, who was the founder of High Point. During his manufacture, every breech face that is manufactured with High Point is pressed against a grinding tool, which produces these very distinct characteristics. And according to Mr. Deeb, he does this to allow forensic laboratories to have marks that better allow them to identify ballistics fired from his firearms. Milling is another process that we see a lot with breech face marks. But it can be used on extractors, ejectors, cartridge feed ramps. But there's two types of milling we generally encounter. Plunge milling, which gives you this circular mark here. And then plunge milling with lateral movement gives these like arced impressions. And when you see these on fired ballistic evidence, this is what it looks like. These are both fire cartridge cases. On the right, this is a plunge mill operation, as you can tell by the concentric circles. On the left, rather, I'm sorry. But on the right, this is milling with lateral movement, which is what gives you these arced impressions. Broaching is a cutting tool that can be used internally for a barrel or externally for, say, a breech face. And this process results in a series of parallel lines on the surface, as you can see on this fire cartridge case here. These parallel marks are a result of a broaching process. Now, in terms of subclass characteristics, broaching can produce subclass. Again, it does not mean that they will be there, but let's just say we were to see two, really distinct unchanged lines from one area of this breech face to the other. Examiners are trained through their microscopic experience to notice them, right? Identify them, but not use them for their identification or elimination. So they will not be considered when they're making their same source determinations. This is internal broaching, and this is where you would use a broach, typically what's called a gang broach, to rifle a barrel. And this is a gang broach here on the left. And this broach consists of a series of cutters with the dimensions of the rifling, increasing in diameter down the row of broaches. The widest one will do the last cut in the barrel. So this, this one here will cut. This one will cut a little deeper. This one will cut deeper yet. The final broach to pass through the barrel is the one that will leave its individual characteristics on the rifling. So I highlighted this photo here. This is a cutaway of a rifled barrel. In the yellow, you can see, again, these parallel lines indicative of broaching. But here you see these perpendicular lines. These are lines created by previous manufacturing methods. Okay, both will leave different markings on the surface of the bullet. Okay, I'm going to show you this video that will give you a pretty good idea of, okay, I don't know why that's not going to work. I'm sorry, I'm just going to open this here for you. Can everybody see that?
Yes.
Okay. So this here, this bottom portion here is what we call the workpiece, okay? And that workpiece could be your barrel, your breech face, whatever piece of metal is being cut. This is a cutting steel process, magnified and slowed down. This portion here is the actual cutting tool that's going to move across the surface of the workpiece. And this area is the metal being removed. What I want you to pay close attention to is this area here, the tip of the tool. So at this point right here, the actual tool is cutting the metal, but you're going to see here what we call built up edge. That's a form of chip formation, and it's due to the pressures of cutting that metal will form and fuse and build up on the edge of the cutter. Think of like a snow plow traveling down your street, and ice and snow build on the front of the plow. As it builds to a high extent, it will break off. Sometimes the plow will go over it. It will break off and tumble to the sides. And as the plow continues up the street, the buildup will continue and the break off will happen. This is the same thing that happens during metal manufacture. So you can see this built up. I want you to take a look right here. At this point, the cutting tool is not removing metal. It is this portion of the built up edge that's actually removing the metal. And you'll see that this changes. It's growing larger and larger. And right here, it breaks off. Okay, so now at this point, that built up edge has broken off. Sometimes what will happen when that breaks is it will take small chips of the cutting surface with it. So that increases tool wear and the change of the cutting surface, as well as individuality from the changing built up edge. And that quickly, you'll see the built up edge continues again. I'm going to let this play for a few minutes. And now in this view, this is just a little closer. You'll see a portion here where the cutting tool is nowhere near the surface being cut. The cutting is actually occurring from this built up edge. So If you hear a firearms examiner refer to every time a hard metal via cutting tool passes over a softer metal, the surface of the cutting tool changes so slightly as it continues to pass, that is as a result of this built-up edge. I'm not going to play the whole video because I'm on a little time restraint, but I just wanted you to see how this happens and how this cutting changes, okay? So another process is filing, also known as hand fitting. Sometimes components need to be hand filed in order to fit properly. If you think of a revolver and a cylinder that swings out, hand filing is often needed so that the cylinder fits tightly. And these are noticeable again under microscopic comparison. Now this is a microsill here, microsill cast of a breech face. And the black arrows here are pointing to parallel lines. And as we just saw, parallel lines are a result of a broaching process. So this would be external broaching. But these angled lines here, these are a result of filing. And filing by nature produces individual characteristics. You're not going to see subclass carryover from a filing process. And these are often encountered when doing examinations of revolver breech faces or fire cartridge cases from a revolver. You have some other metal removal processes that do not involve typical cutting, okay? They're either burnt away or cut away on a molecular level using conductive fluid and electrolytic fluids. This is actually an electrochemical cathode. Right here is the dimensions of the rifling. This would be used in this ECM process. And this will be inserted into the barrel along with electrical current and the electrolyte. And molecularly, the chemical reaction would cause the metal from the barrel to separate in random pieces and move toward these metal rifling characteristics. A fluid will wash those away, and the depth of the rifling is determined by the speed at which this cathode passes through the barrel. But what results from that is a surface that looks similar to this. It's often referred to as pebbled, but a firearms examiner would call this a granular surface. And this is also individual. There's no chance of subclass carryover in a process such as this. This is typically used in barrels as well as on breech faces. So here's the takeaways from machining, and that's not an all-encompassing review of all processes, but I wanted to give you a good baseline of some of the training and familiarity that an examiner will have in terms of manufacture. But the tool marks on a finished surface are predictable based on the machining process, right? We know broaching makes parallel lines. We know that filing makes irregular, often angular marks. An examiner can examine the finished surface and possibly determine by which means that surface was machined. Okay, if I see a granular breech face, then I can eliminate the fact that there was any broaching on that breech face, and therefore I can eliminate any possibility of subclass characteristics. And then machining methods differ in how they produce individual characteristics as well as the potential for subclass. So I want to talk a little bit about the reliability of the evidence. And when I say that, I think a lot of this comes down to, and I'm sure the judge will elaborate on this, the examiner's training, experience, and methodology, and their ability to articulate to the court how they are able to examine evidence and reach a conclusion. So I think everybody's probably familiar with the 5 prongs of Daubert. In Philadelphia, we are a Frye state, so a little less stringent as Daubert. It's typically what's acceptable in terms of having knowledge exceeding that of the average person. But the NAS report, I think, really brought out some deficiencies in pattern evidence. So a lot of work has been done to actually meet these 5 prongs of Daubert. So testability and validation of methods. And I think this is really going to relate to conviction integrity cases, especially if you're dealing with cases that are 15, 20 years old. Some of these things probably weren't in place in the laboratory at the time of the examination. So there have been a number, many validation studies supporting the reliability of firearms and tool mark examination. When I say a validation study, that's going to relate basically to the premise that different tools make different tool marks, and they're demonstrated through computer-based studies, okay? There's a number of different types, including congruent matching cells, virtual comparison microscopy, and an array of various statistical models. And then you also have examiner-based studies, which will test the individual examiner's ability to reliably discern tool marks made from different tools. And many of those studies involve consecutively manufactured components, whether that's barrels, breech faces, firing pins, extractors, etc. So I think that all goes towards the testability and validation of methods, as well as quality assurance programs, which require the validation of any instrumentation prior to being used in casework, and also mandates that only valid methodology and testing is permitted within the lab. I don't say this to suggest that a lab that is not credited is not going to produce quality work. However, I do think that laboratory accreditation has really helped to standardize the field as well as the general forensic science community. Peer review and publication, this was another valid critique from the NAS report. Basically, you know, the critique was that firearm and tool mark studies were published in the AFTI journal. AFTI is the Association of Firearms and Tool Mark Examiners. And as a result of that, the only people who had access to those studies were firearms and tool mark examiners. I can say that as a result of the NAS report, that is no longer the case. This is a short list of various forensic science journals, as well as legal journals. There's journals on standards, technology, statistics, research, education that are publishing studies on firearms and tool mark evidence. The known potential error rate. So there's two things that you could look at. Collaborative Testing Services is a proficiency test provider. That happens to be the provider that we use in our laboratory, which will produce, will publish the results of proficiency tests. Now, there's one thing you need to understand with that. Proficiency tests will not provide.
Oh, yes. Thank you.
I'm sorry. Proficiency tests will not provide a discipline-wide error rate. They will provide an error rate for the examiner who took the proficiency test, okay? However, you could take the average of the published proficiency test results and get a good idea of what the typical error rate is among the whole field of examiners who took those tests. Now, it depends on some laboratories. In some laboratories, trainees are allowed to take those. There are also people who can purchase the test and take it and submit it on their own who are not qualified experts. So some of the results can be a little skewed, but you could also look at proficiency test results of the expert on the case that you are working. And then you have error rate studies. And again, this is not all encompassing. This is just a list of a few error rate studies using, consecutively manufactured firearm components, looking at decisions by examiners and testing false positive and false negative error rates. But again, keep in mind, this is not a discipline-wide error rate. This is an error rate for the people who participated in those studies. Now, again, you could look at those studies collaboratively or collectively and come up with an average, but we do not have a discipline-wide potential error rate. And then, of course, the existence of standards and controls, and a lot of this has to do with accreditation requirements that probably were not in place in a case that was handled 20 years ago. So standard operating procedures in the lab, equipment calibration records, and calibration schedules. In addition to that, all equipment calibration is traceable. Okay, so any re-examination that's conducted today, you should be able to trace back any equipment that's used and get reliable data as to its calibration history. We also have the Organization of Scientific Area Committees for Forensic Science. We call this OSAC. And OSAC has published a registry. They have both published as well as in progress standards that are open to the public, and they define minimum requirements, best practices, standard protocols, and other guidance to help ensure that the results of forensic analysis are valid. And these standards are for examinations of firearms, microscopic comparisons, training, education, implementation of 3D microscopy, and so forth. So they're very broadly and working on numerous areas within the ballistics community. Also in our region, in the Philadelphia region, we have the Pennsylvania Forensic Laboratory Directors Working Group. I am on the scientific working group committee of that body, and it encompasses Allegheny County, Pennsylvania State Police, and the Philadelphia Office of Forensic Science. And we collaborate and review OSAC requirements to ensure that all of our laboratories are meeting those requirements, and also standardizing the testing that we provide and the results that we can provide, so you will have quality examinations throughout the Pennsylvania region. So again, laboratory. Go ahead, I'm sorry.
Nope, it's okay. Just a little feedback, but it's fine.
Okay. So laboratory accreditation, again, keep in mind, these are minimum requirements for forensic testing laboratories, okay? These are just some of the areas that are covered, right? Comprehensive training programs, proficiency testing schedules, independent verifications, equipment validation, and so forth. I think what's even more important than this is that laboratories can institute policies and procedures that go above and beyond accreditation requirements. So in our laboratory, we do have some requirements that go above and beyond what our accrediting body requires, okay? Just a side note, we are accredited by ANAB-ANSI, which is the National Accreditation Board under 17025, which is the accreditation for forensic testing laboratories. But there are other laboratory accreditation bodies. General acceptance in the relevant scientific community. So again, OSAC was created in 2014 to address the lack of discipline-specific forensic science standards, which again was a criticism of the NAS report. And it fills this gap by drafting those proposed standards that I spoke about. I think what makes this unique is that it's made up of over almost 500 members of both laboratory personnel, but also personnel in other scientific areas, those in scientific research, measurement science, statistics, as well as legal experts. So it's not a bunch of firearms examiners who are sitting around developing standard operating procedures. There's input from everyone in the relevant scientific community. And I think that has really helped to advance some of the methods that we use that probably weren't available in the older cases that you may be dealing with. And then there's the NIST Ballistics Toolmark Research Database. It's an open access database of 3D topography and 2D image data of both bullet and cartridge cases, as well as other toolmark surfaces. So that will include your screwdrivers, pliers, etc. But it provides a variety of crime lab test fires, as well as test fires using consecutively manufactured firearm components. The purpose of this database is to allow researchers access so that they can test new approaches to provide objective, mathematical-based toolmark identification. So anyone familiar with pattern evidence knows that it is subjective in nature, right? As of right now, we are unable to provide a probability or a likelihood ratio or any type of quantitative mathematical based weight to an identification or to a finding. I don't know how close we are, but there's a lot of work that's being done in the last 8 years or so. I really think within hopefully maybe the next 5 years, we'll be able to provide some type of weight in the likelihood of identifications. And then there's CSAFE, who also was developing automatic matching algorithms, also for the purpose of trying to provide objective assessment of pattern evidence, okay? Which again would be quantitative versus subjective or qualitative. And their projects right now include the statistical algorithmic approaches to matching bullets and cartridges, the effects of subclass characteristics on cartridge case comparisons, and then evaluating the foundational validity of tool mark analysis, again, meaning do tools produce different tool marks? And how can this help you in conviction integrity cases? So there's a couple things to really point out. Quality forensic laboratories seek the truth, okay? Everyone in the forensics, I don't want to say everyone, I could say that forensic scientists are working to provide you answers to the evidence that they examine, okay? Those answers should not be skewed or tilted or driven towards one side or the other, okay? And therefore, the forensic laboratory should accommodate reasonable requests for reexamination and testing. I emphasize reasonable because if you were to say, ask a laboratory to microscopically compare the evidence on your case with every other shooting incident that happened in their jurisdiction, right? That's not feasible and therefore not reasonable. However, to ask for evidence on your case to be re-examined by a new firearms examiner, again, if it's an accredited lab under laboratory accreditation, right, with the reliability of equipment and methodology and operating procedures, the laboratory should accommodate that request. I have worked with the conviction integrity unit of our district attorney's office, and when they ask for re-examination, we assign that case to an examiner, okay? That re-examination is conducted independent of the initial examination. We're not giving the examiner the old report and saying, hey, agree with this, right? They're given the evidence and told, conduct an examination from start to finish. One of the other benefits of laboratory accreditation is comprehensive case notes that pertain to all the analysis conducted and the interpretation of your results. I can tell you that years ago, 20, 25 years ago, a laboratory report probably consisted of one page, right? No casework or no case notes, no documentation of equipment used, no documentation of a secondary independent validation or verification of findings. You're going to get all that now with accreditation requirements. This next one's really important to me. Expert witness is available for case prep with defense counsel. I say this because I think, again, that there's maybe a misnomer that examiners work for the prosecution, right? Especially if you're under the umbrella of law enforcement. I can tell you that I've prepped on numerous occasions with defense counsel, whether that be prior to court or in the hallway of court or in a side room or over the phone. One side story, I had a defense expert call me on a case he had. It was a police shooting, and his client was arrested with a firearm, and he was really focused on the gunshot residue in the barrel, right? And could I determine when that gun was last fired, or had it ever been fired? And he was really focused on the firing of this firearm. And I stopped him and said, I want you to know that I don't have any ballistic evidence on this case that was matched to your client's firearm. So from what was submitted to me, either your client's firearm was never fired, and if it was fired, evidence wasn't collected and submitted to me, and therefore I couldn't give an opinion on whether or not that even occurred. And he was a little taken back. I think he was surprised at my openness. We talked for probably another 15 minutes or so, and he was really appreciative, and I think he sounded really surprised at my willingness to speak to him. And I don't want people to think that your expert should not be open to prep with you. I'll take it a step further and say the expert witness should be willing to prep with the prosecution and the defense together, because it doesn't matter who's asking the question, the answer is the answer. And your expert should be open to do that. It's not to say that attorneys are necessarily going to be open to that, but your expert should not be opposed to that. So again, when you're dealing with conviction integrity cases, reach out to the laboratory, speak to the expert. If you have questions about their findings or maybe additional testing that could be conducted, For example, if you have a case that's old where you have stippling, which is gunshot residue particles, right? Both burnt, partially burnt. They could be on clothing, they could be on skin, so they could be on photographs from the ME's office. And you have a suspect firearm. If you think a distance determination study could provide good information for your case and that wasn't conducted, as long as the pattern is still available, whether that be photographs or the actual clothing, and the firearm is available, and we know what type of ammunition is used, a distance determination study can be conducted, and that may prove to give you useful information. And also requests for defense expert access should be accommodated. So again, if there's evidence you need to view, testing that you'd like your own expert to do, we have defense counsel come down and take photographs of guns and serial numbers, etc., microscopic work. The laboratory should accommodate you in that request, because the goal is for the truth, and we don't have any weight into which side the truth lies. Also, there's current trends and new developments that really could be helpful in your investigation. Primarily, I think the most helpful at this point would be database searches. So NIBIN, National Integrated Ballistic Information Network, is used across the country. It houses digital images of crime evidence as well as test fires. We started a program back in 2016 that initiated a comprehensive entry of all evidence. That's really been adopted throughout the country. It's used as more of an investigative tool now. But in our work with the Conviction Integrity Unit, I have cases that went into NIBIN, 10 years ago, but all of our evidence was not in NIBIN as of 10 years ago. Now everything goes into NIBIN. So when they make a request of, hey, was it entered in the NIBIN? And I tell them, yes, it was, but we can re-enter it if you want, because let's just say there's been a gun recovered in the time since your case was prosecuted, okay? And that evidence hits on the test fire from that gun. That could be very useful for you in your investigation. So certainly request database searches are conducted, even if they were initially run. I would ask for a re-entry because new information could be available. And then 3D comparison microscopy, quantum 3D microscope, the Cadre virtual comparison microscopy. They are 3D images of ballistic evidence, okay, that are scanned into the database, and examinations will be conducted in the future without access to the physical specimen. So may not help you now, but for future conviction integrity cases, we all hear the stories of evidence lost, destroyed in a flood, a fire, etc. Future examinations can be conducted even if the physical evidence does not exist anymore, as long as it was entered into a 3D comparison microscopy database.
Anne-Marie, there's a question in the chat. What year did NIBIN database begin? How far back does it go?
I believe it was instituted in the early 90s to the mid 90s. It was done after, I believe, Ceasefire might have been the first program. In Philadelphia, we got our first NIBIN system in 1997. So I believe it was around the mid 90s. The difference really is that early NIBIN was used as an afterthought. In our lab, for instance, I had cases that I testified on, convictions, were adjudicated, or convictions resulted from the court hearing. And then a week later, after my evidence that just went into NIBIN prior to court, it then, it hit on a gun or it hit on another shooting after the case already went to court. Now NIBIN is used as an investigative tool, and you're seeing a lot of laboratories getting NIBIN in within the first 24 to 72 hours. And that's actually mandated now by the ATF. They have minimum required operating standards for the collection and entry of ballistic evidence. So it's a very, very helpful tool. And even if, like I said, your evidence went in years ago, even the imaging capabilities are much better now. So I would always request that evidence be re-entered into the database just to see if it produces any leads. And of course, they're only leads, okay? If there's a hit on a case, it doesn't necessarily mean that that's the item. It would require a microscopic comparison, but at least it could point you, in a right direction. And one last thing on the 3D comparison, the virtual comparison microscopy, I think that there's a possibility that will be used in the future in the courtroom, where the examiner will be able to show the court the examination process, the areas of individuality, or the areas of repeating patterns that they used during their conclusion-making process. And then therefore the jury could take the testimony of the expert as well as what they witnessed on the video. And I think the judge could probably provide a little more information on that in terms of, being reliable in court or accepted in court. But I think, maybe within the next 5 or 7 years or so, I wouldn't be surprised if that's what we see. So that's all I have. I know it was quick. I apologize. I just tried to get a lot in. So if anybody has questions.
Not to worry. Thank you very much. And as promised, we'll go to the view from the bench for Judge Grimm. And I muted you, Judge, sorry for the background noise. So you have to unmute yourself.
There we go. So that was a wonderful presentation. I can tell you that if all toolmark and ballistic experts provided that kind of testimony at trial or at hearings challenging this evidence, I think that the lawyers would be much happier and the judges would be much happier and feel that they had a much better ability to be able to get a result which is consistent with trying to find evidence from which the jury can make a just determination, which is the goal that we all have. Now, what you need to understand is the focus of many of you on this call will be convictions that occurred in the past. And in some instances, that may mean that you are looking at a methodology used by forensic examiners that is no longer considered to be accepted methodology. And it may be the instance in which, for example, the test of admissibility has changed. So we know that the last time the federal rules of evidence were changed was in 2000. There's a proposed change that is coming around the corner that will take effect on December 1st of this year, unless stopped by Congress. And that will be the first substantive change to Evidence Rule 702 in 20 years. And it specifically is addressing some of what the Evidence Rules Advisory Committee thought was some fine-tuning needed by trial judges to properly fulfill their obligations under Evidence Rule 104A to make a preliminary determination regarding the admissibility of evidence, the qualification of witnesses, and the existence of privileges before allowing that evidence to go to the jury. And I think there was a concern that the Evidence Rules Advisory Committee had, that trial judges, particularly if they were faced with competing evidence, where you had an expert for the prosecution saying, expressing a conclusion and discussing methodology used to reach that conclusion, and a defense expert expressing a contrary conclusion, that rather than trying to decide independently whether each of those two views was meeting the requirements of sufficient factual basis, reliable methodology, and reliable application of the reliable methodology to the facts of the case, the trial judges were tending to just say, well, I'm going to let both versions go in, and then the jury can decide the weight to be given to it. And the new changes to the rule will emphasize the duty of the trial judge to make a determination that the proponent of the evidence in a tool mark evidence case is it could be, generally speaking, it's the prosecution offering it and the defense trying to rebut it. When the defense has an expert showing that the following things have been established by a preponderance of evidence, the qualifications of the expert, and I think that you've heard some remarkably helpful information about the status of qualifications and training peer review testing certification that has occurred within this area of examination, forensic evidence, that really speaks highly for how the forensic tool mark and firearms experts have taken seriously the shortcomings that were originally identified by the National Academy of Sciences review of forensic evidence that happened, I think, in 2008, 2009. And then more recently, the President's Advisory Council on Science and Technology, PCAST, that occurred in 2015, and their supplemental in 2016. Some various types of comparison forensic evidence was very resistant. The firearms folks listened carefully, went out and have done an enormously commendable job of addressing, and then wherever they could, exceeding some of the minimum standards. But what you need to keep in mind is that the requirement for establishing qualifications, sufficient facts, reliable methodology, reliably applied, is preponderance, more likely than not. Now that's 51%, just slightly better than a coin toss. So the bar that you have to clear, while it does require that you meet these reliability factors, ultimately that has to be shown by the proponent by a preponderance. And so that will still make it possible to have evidence by prosecutors that is subject to cross-examination and challenge, but meets the minimum test for being heard by the jury. And then, of course, the obligation is for the defense to meet it when they can meet it. This can create resource problems. Some of the cases that you'll be dealing with, depending upon whether there are state or federal cases in the federal system, the federal public defenders have resources to be able to hire their own experts. And judging by my experience with federal public defenders in the state of Maryland and elsewhere, in the state level, they are remarkable and dedicated and passionate and creative lawyers. And the Criminal Justice Act Council, at least in the District of Maryland, where I'm most familiar, were highly qualified defense attorneys who also, while they mostly didn't have access to experts that they could hire on their own, they could go to the court and seek permission and funding to be able to hire an expert. And I'm unaware of an instance in any test where there was a legitimate issue where the court did not agree to provide that funding. I don't know that you're going to find that same level of funding available or even qualification of the defense attorney in state cases, particularly going back in time. This is all you need to do is to read, habeas corpus opinions challenging effective representation by counsel to realize is that not all defense attorneys are the product of the same tool mark identification when they were stamped out of the same mold. Some of them are more thorough and more competent than others. And I think that what you need to be careful about is, particularly when you're looking at case law to support an argument regarding admissibility or inadmissibility, that you look at when that case law was written, whether it was a standard that employed the Daubert standard or whether it was Frye-Reed. While there is overlap between Daubert and Frye-Reed, because Daubert does include general acceptance by the relevant scientific and technical community, which is what is the essence of the Frye case. A number of jurisdictions do not have it. An interesting case study is in Maryland, which in 2019 or 2020 adopted the Daubert case after having its own version of Frye, which is referred to as the Frye-Reed test. In a decision that the Supreme Court, newly renamed Supreme Court, previously known as the Court of the Maryland Court of Appeals, I'll probably mispronounce this, it's Abruqua, it came out, and that's an example of some of the issues that you're going to face as you deal with these cases. It was a homicide case, and there was a crime scene, and the defendant the victim was shot multiple times. There were bullets that were in the body and bullets that were found at the crime scene. The defendant and the victim lived in the same place, same house. They found the firearms of the defendant hidden in the ceiling in the basement. So they had the ability to test the evidence that was found on the defendant and then test what they found at the crime scene. The original trial took place in 2013, and that was done under the Frye-Reed test, general acceptance. Evidence came in, there was a conviction, it went up on appeal, it was bounced back by the Intermediate Appellate Court, came back to the circuit court, the trial court, for another trial. This time there was a 4-day evidentiary hearing, which is really remarkable. That's a very I mean, I've held Daubert hearings in firearms cases. I've had them take all day and I've had them take a day or two, but 4 days is a pretty comprehensive examination. I think there were 5 or 6 witnesses who testified. And then the judge ruled, partially granted and partially denied the Daubert or the motion to suppress filed by the defense. Found that the then existing standards being used by the forensic examiners in that particular case were generally accepted by the relevant scientific or technical community of forensic scientists, but did not support the ability to reach a conclusion that the marks found on the crime scene sample, when compared to the example shot through the weapon that was the defendant's weapon, that it could conclusively either establish that it was or wasn't, although it certainly could show marks that were consistent with. That case went to trial, it produced another conviction. It went up to the Supreme Court. In a 4-3 decision, 4 of the justices of the Maryland Supreme Court found that while the evidence that had been used under the testing and methodology at the time, and remember, we're going back to years before, and before the Maryland court even had the Daubert test, that it was sufficiently qualified, reliable to support a testimony that there were similar characteristics between the defendant's firearm and the samples taken at the crime scene, but that an unqualified opinion that either ruled in or ruled out was not supported by it. And the result was that the Supreme Court of Maryland felt that the evidence allowed in by the trial judge, even after all these hearings, after the successive evidence on the third try, did not meet that, and so they reversed. There was a dissent, and the 3 dissenters thought that it would have met the standard. So I think that the key that you need to take out of all of this is that there are earlier cases. The first time I had one of these challenges was probably 15 or 16 years ago. It was not the same methodology, the same accreditation, the same care and attention that was being taken by what you have heard about today, which I think is really, Anne-Marie's testimony about what her lab does is really pretty phenomenal. And I think that it goes a long way to building credibility, not just before the court and the jury, but also in the eyes of defense counsel, when you have an expert who's accessible and willing to go back and show their work. But when I had a lot of the examiners were former detectives. They were not folks who had a scientific training and had gone through the level of testing and certification that Anne-Marie has described is the standard today in the reputable crime labs. But they had been, they'd been a narcotics police officer, or they'd been doing something for years, and then they just took a training course, and they went off and did it. When they were doing, peer review, they would have someone else in the lab look over their shoulder and look at their results. But as Anne-Marie told you, that's what the answer is. When I know that one of my colleagues found it was a match, and I look over the shoulder, then I know what that is. And you have confirmation bias that can come in, and I think that when you get into some of the recommendations that currently exist in terms of how you do it, particularly since you have people like CSAFE that have brought in statisticians and measurement scientists and others to try and look at this. The state of the science today has dramatically improved. I think a tremendous amount of credit needs to go to people like Anne-Marie and her crime lab that have that have taken these efforts. The reviews are no longer done only by the people who are within this science, who originally all started off as in some sort of law enforcement background. And given technology now and the ability, quite frankly, of artificial intelligence analysis to be able to look at some of these copies, that even if the evidence is no longer available, but you have it, it's been in one of the databases, to go in there and examine it at a level that even electron microscope can't detect, and see whether they have samples, gives promise for even greater ability to check accuracy in the future. The challenge that you have is you're bound by the standard that was being used at the time of the case that resulted in the conviction that you're now challenging. The evidence that was there, the legal standard that was applied by the court, and what standard would be used when you try to go in there and attack the conviction later. Do you use a modern standard? Do you use a former standard? Some states, I think, and Anne-Marie, you would know, Marissa, you would know, and I'm sure our audience would know better than I think that there's some states like Texas where some of their crime labs 20 years ago were considered to be well below par, and now the Houston crime lab has sort of changed all that, and Texas has taken remarkable steps to improve the science behind their forensic science units. But I think Texas is one of the states that's adopted a statute that allows you to re-examine scientific methodology for old convictions where science has changed significantly from what it was at the time of the conviction. That's a remarkable kind of a statute that allows a new defense attorney to come in and try and get new testing done to do it. I think that a willingness to do that and to subject it to the modern techniques and to get a retest, as Anne-Marie has said, goes a long way towards fulfilling the goal that we all have, is that the result of the trial has integrity, and that justice was done as best as you can have in an imperfect system where facts are competing, and we rely upon lay individuals to make these decisions, even though they're involving issues of technology and science that are beyond their ordinary experience, which is what you need before any expert can testify. I think that what I get some of the greatest I think makes me feel most hopeful is that I can compare the testimony in the case I had back in 2010 or 11 with the testimony of the case I had when I was a district judge. There, the examiners were no longer trying to say, I mean, there was a time when they made claims that were just simply preposterous, that they could with absolute certainty exclude every other firearm ever made and that ever would be made. And they made statements that were so grandiose and so incredible that no reputable scientist would ever make those kinds of statements. Yet they made them. They came across as partisans. They came across as people who were dug in and would not yield on cross-examination. And as a result of that, their credibility was often looked at suspiciously by courts. And I will tell you that in the cases that I have had, when I allowed the firearms forensic evidence to come in and talk about the approaches all the way up before they said, and in my opinion, to a reasonable degree of certainty, this gun fired this bullet found at the crime scene. I wouldn't allow that. I didn't in either of my cases. But I allowed the expert to come up and talk about all the methodology, talk about, they didn't have your PowerPoint, Anne-Marie. It would have, I think, really made a big difference to the jury and also to me. But they'd explained it step by step, and they did have pictures and slides, and they actually showed comparisons, and they explained why it is that this line here, which matches up with this line, is one that they thought was significant, but these lines over here that were different. You saw the slide that Anne-Marie had, where if you got out in the concentric circles, out into the far regions, the marks looked differently, but when you got into the center, they lined up, and why it was that those center marks that lined up were more important to the evaluation than the ones out there in the side, and we're able to explain it. And even without going that step where they try to express an unqualified opinion, which I think judges are probably reluctant to do. And I think probably most good examiners don't do that now. They don't need to. And I found that, first of all, the jury pays rapt attention to this. They appreciate it when you don't point the gun at them, as our conversation before we started the program was. But they pay close attention to this, and they consider it carefully. And it's in the cases I've had where the examiner testified not to those ultimate conclusions, but to this point that came up to it and talked about similarity, and to express an opinion that there were similar marks on the one that was found at the crime scene with the defendant's gun. The jury had no trouble finding for the government. So I think that when you play by the rules and do the kinds of things that Anne-Marie said, that juries get it, and it's not going to come up with, if you have an examiner with the credentials, with the training, with the care and the explanation, and with the new science and resources and databases that we're now seeing, I don't think any competent prosecutor or needs to worry about the jury not being able to have sufficient evidence to convict if you do not try to overstep what the science can allow you to express an opinion as to. So I think that the success of this area of forensic science is that a lot of hard work has gone into changing the status quo now as to what it was back in the time when the cases are that you're looking at. And what you need to do is, obviously, when you get your cases, you have to go in there, start with, what's the evidence that I have available now? Do I have the actual evidence, or is that gone? Am I limited to photographs? What was the standard that was done? What's the standard that's going to be applied when I argue my case before the judge who's going to re-examine it? What's my standard of proof? What do I have to show? What is the am I able now to take advantage of the changes in technology and have a re-examination and come in and bring this evidence here? But I think that that what we can learn from this is that even in the past, with the methodology that I think has been subject to criticism, there were very few judges who flat out excluded the evidence. They would dial back what the opinions were that the expert could give, but very few that actually specifically said that it was totally inadmissible. And in my experience, you didn't need to go that final step of coming up with the preposterous testimony that it was 100% certainty to the exclusion of any other firearm ever manufactured ever. And you didn't need that. And it sounded so preposterous that it was really self-credibility defeating as far as I was concerned. So I think judges now are getting a lot of benefit from the new technology and law that happens. I know judges are interested in this, and I suspect that in the posture in which you all are getting these cases, you're going to have a hearing. I mean, by very definition, you're going back to look at this evidence and try and determine whether or not standards, whatever the operating standard is going to apply, were met or were not met. And so you're going to have a judge that is going to have the hearing, and you'll have the benefit of having whatever was done in the past, comparing it to what is being done now, and whether that gives you a different result or not. And so you have a lot more material, I think, to work with now than you ever did before. So I think the state of where you are in this kind of litigation is very promising. I wish all of the so-called forensic science disciplines had taken the same kind of approach as the firearms experts. I think the firearms experts have really led the pack. And as a result of that, keep in mind that your trial judges are generalists. They're not specialists in all of this. They depend upon the adversary system for the parties to come forward with the evidence that makes the clash. While there are abilities for judges to have court experts or court technical advisors, it's not often done. Your trial judges are very busy, state or federal. I don't know any judge that has leisurely time. So they have a limited amount of time in order to deal with that. These issues need to be raised early, well before trial or hearing, so that you can have a hearing, however many days it's going to take to get the information there for the judge to make the standard call. And then once that's been done, and the evidence has been admitted, then upon appeal, obviously the appellate, there's a great deal of discretion given to the trial judge to the opinion that's raised, but it puts a real premium on careful preparation, carefully understanding the evidentiary standard to be applied, diligent looking at the evidence that existed and comparing it to what the evidence may show now, and talking about how the procedures may have changed, and then making an argument to the standard that will govern the outcome of your case as to whether or not that evidence would be admissible today or would not be admissible. So those are my observations. I don't have a PowerPoint because my entire life, everyone who's ever looked at one of my PowerPoints has given me a score that said that I broke every rule that you could possibly break with a PowerPoint. Rather than having images and a few words, I would have PowerPoints that looked like I was trying to inscribe the Gettysburg Address on the head of a pin. And it would take Anne Marie's electron microscope to be able to read the slides. So I did you a favor by not having any slides, but the slides that Anne Marie had were really excellent and helpful.
And we appreciate that, Judge. I'm just going to add Anne Marie here in terms of so folks can all see her. Anne Marie, did you want to add anything in from what the Judge is saying? I'm going to remind you you're muted.
Oh, yes.
There you are. Okay.
Thank you. I do. I just want to add a little something because the judge made a really good point about how things were even presented, right? In terms of methodology, for instance, years ago, comparisons were made using bunter marks. So for those of you who don't know, bunter marks are the letters and numbers that are stamped onto the head of a cartridge that would indicate, 9mm Luger PMC for the manufacturer. Those areas were looked at for comparisons years ago. Well, testing was done on boxes of ammunition from different lot productions, and it was determined that the individual marks within the bunters matched in different boxes of ammunition. So years ago, you might have had a case where a box of ammunition was recovered from a suspect. They looked at the bunter mark, compared it to the bunter mark of crime evidence and said, oh, that ammunition came from his ammunition box or her ammunition box, and therefore there's a link. That's not valid anymore. Yeah. It's important to understand, look at your report and see what comparisons were made, because things like that now, an expert would never testify to that. We won't even examine it because it's invalid. And even with the wording, as the judge touched on, with the elimination of every other firearm that exists in the world, even more innocuous than that, little statements like inconclusive microscopic markings to permit an identification. What about an elimination, right? Isn't that leading to someone who is reading a report who doesn't know ballistics and they see, oh, I eliminated it because there's not enough for me to say that that's the gun. Well, a lot of times an inconclusive means it's not enough for me to say either way. There may be some agreement. There also may be some disagreement. Or you may have a case where there's such a lack of individual characteristics present at all that you can't make a determination. But little wording like that can really be taken with more weight by someone who's untrained. So I think it's important to, again, review that report, look at the wording, see if that's consistent with the type of testimony that's given today. Because we've really come a long way. Some of those things make the hair on my neck stand up when I hear some of those old statements, but it was a time where an expert could get on the stand and say, I know better, and it's a match because I said so. And they weren't really pressed on how are you able to do that. And again, even with the training today, training in machining is so much more extensive. If you don't understand machining, you can't understand how individuality occurs, and therefore then how could you make a reliable assessment of evidence? Mm-hmm. So there's a lot has changed, but you mentioned a few things that, made me sweat a little bit because I thought back to some things that I've heard over the years, and, so just really read over the reports. See also case notes. I think a lot of times years ago, people feared case notes. They were I don't want anybody getting my notes. I don't want people to see what I did. I want you to see what I did, because what I did is validating the conclusion that I made. It's showing you how I came to the answer that I put on my report. Your notes are there to help you and to back up your conclusions and your methodology. When you had, and again, I don't want to say that people without science backgrounds, I know a lot of really good examiners who didn't. But I think when you have knowledge of science and apply it, and you're used to laboratory policy and protocol, it comes easier to you. Case notes are not your enemy, they're your friend. So a lot has changed. There's a lot more that's available. And again, I say if you're working a case and you don't know, reach out to the lab, send them the report, ask questions. That's what we do. I've had email chains back and forth with our conviction integrity, answering questions of what possibilities could have happened or what we could provide, and that's what we're there for. So really, utilize the laboratory.
So I'm going to just jump in on that because I think it's very important. I know a lot of defense attorneys, one of the quandaries that they have, and it's a legitimate issue, is if I hire an expert or I go back to the lab and I ask them to take a look at it again, and they do, and it supports the original outcome, then I have really harmed my client. And what I would say is, I don't think that it harmed your client at all. You can decide whether you want to raise it and use it or whether you don't. But I don't think, I think that taking a sort of a head in the sand approach because you are afraid of what the outcome will be is the wrong way to look at it. If the outcome is what the outcome is, if it's against you, then you can fashion arguments as to whether or not, even with it's against you, it should be admissible or should be considered or given the weight that it was given. But if it's going with you, then you have that. And of course, just by getting the report, if you ask for it and get it to them, unless it's some sort of a reciprocal agreement where the prosecution is going to get it, if you get it, then I understand why there might be a reluctance to do that, because you don't want to, it's the old thing about the joke about the people trying to, the hunter trying to outrun the bear, and
Right.
the bear is chasing after him, and he jumps over the stream, and the bear jumps over the stream. Before he does that, he makes a prayer, let me lose the bear over the stream, and the bear makes it over the stream, runs up the hill, and doesn't lose him, and climbs up the tree, and then the bear is coming up the tree, and exasperatedly looks up and says, well, if you're not going to help me, at least don't help the bear. The idea is that there's sometimes defense attorneys who are reluctant to help the bear. They don't want to prove something that would help it. But and while that may be a legitimate concern, getting information, reaching out, getting people like Anne-Marie who can come to you and explain it to you is going to make you understand a lot better and do a much better job for your client in the long run.
Right. And I will say, I know we are just about at time, but I'm going to ask Anne-Marie and the judge just to hang on just a couple more minutes, just in case people do have questions. I would like to get to those. So thanks everybody for joining us. Next month, we are trying to bring back some of the folks who talked to us about ethics issues to look at Brady and to have some discussions about what does Brady look like in a post-conviction world, and particularly in some of these issues like Anne-Marie and the judge were talking about, where you've got an old test that was done under potentially not reliable circumstances. Is that, if it's new, is that Brady, or are there issues that we can look at? So hopefully we'll get into some of these as a discussion groups for next month. So I hope you all can join us then. And as always, in the meantime, if you have questions or topics you'd like us to cover in the webinars, please reach out. We're always looking for help. But first, let me just say thank you so much to Anne-Marie and to Judge Grimm. We're just so grateful for your time here. I'm going to go ahead and stop the recording, but I'm going to ask if folks have questions for either Anne-Marie or the judge to just please, you can go right ahead and unmute